Good morning KCGC TV viewers. I am Dr. Saluja, Assistant Professor from Khalsa College of Law, Amritsar. Today, here I will discuss with you what is transfer of property, who is competent to make transfer of property, and what are the various modes of transferring the property. Section 5 of the Transfer of Property Act deals with the transfer of property term. So first of all, I will define here what is transfer of property as per the meaning given by Section 5 of the Act. Section 5 says, transfer of property means an act by which a living person conveys property in present or in future to one or more other living persons or to himself and to one or more other living person. The transfer of property is to perform such an act. Transfer of Property Act provides 5 types of conveyances, out of which 3 conveys absolute interest, such as in the case of sale, exchange and gift, whereas 2 conveys limited interest, such as in the case of mortgage and lease. Transfer of property means an act in which something must be done by the transfer, because the property cannot be transferred automatically, such as in the case of wills and inheritance. Transfer of Property Act provides that property must be transferred by a living person. Transfer of Property Act deals with inter vivos transfers. Inter vivos transfer means transfers which can take place only between 2 living persons. The term living person is defined in the explanation as given under Section 5, which says living person includes company, associations, body of individuals, whether incorporated or not. So the term living person is much wider than the term natural human being. It includes juristic persons. Property shall be deemed to have been transferred when it will be conveyed by one person to the another person. Here, the term conveyance means when there is creation of some new title or interest in the favor of another person. For example, A and B are 2 persons having ownership in their own houses. One cannot claim right of ownership in the house of the another person. But suppose if A transfer his interest in favor of B either by the way of sale or gift or exchange, then B can claim ownership in the house of A. This act of A is called conveyance. In Pandit Mukund Ram's case, AIR 1955, Supreme Court 376, it was held by the court that family settlement is not a transfer of property because there is no any conveyance. There is no creation of any new title or interest in the favor of another person. Family settlement is mere a settlement of already decided claims. It is mere an agreement between the parties where the acknowledgement is made of the title what the parties has. Then in Arlappa versus Jagannath AIR 2007, Karnataka 91, it was held by the court that partition is not a transfer of property. Because again there is no conveyance, there is no conviction of any new title or interest in the favor of another person. So partition is not strictly governed by the provisions of the Transfer of Property Act. But there are some provisions which deals with the partition on the basis of the doctrine of justice, equity and good conscience. Property can be transferred in present or in future. Here, the transfer is having the authority to make such kind of the arrangements in which property can be transferred. Interest in the property can be vested immediately after the completion of the transfer. He can also make such kind of the arrangements where the vesting of the interest may be postponed to some future date. Or he can make conditional transfers also. That means upon the fulfillment of some conditions, property can be transferred by transfer in the favor of the transferee. The term in present or in future qualify the word conveys, not the word property. which means that the transfer of non-existent property is void one. And it was held in the case of Jugal Kishore versus Raw Cotton Company, AIR 1955, Supreme Court 481. The court has made it clear that a person cannot transfer or cannot enter into the contract to make the transfer of such property which is not in existence at date of transfer, because the transfer of non-existent property is void one. Further, this act provides that a transfer can transfer his property only to a living person. He can transfer his property even to a group of persons also. So transfer as well as transferee must be living person at the date of transfer. Transfer must be competent person. He must be of sound mind. He must be of age of majority. Whereas transferee can be of unsound mind. He may be even child and went to a year also, which means that he may be a child even in his mother's womb. The only condition is that he must be in existence at date of the transfer. He may be of unsound mind also. Transfer of Property Act further provides under Section 5 that a transfer can transfer his property to himself also, which means or which is possible that only those cases where the transfer has made settlement of his properties in the form of a trust. Here, the transferor and transferee both are physically the same person. In the capacity of the transferor, he has the legal status of the settler, whereas in the capacity of the transferee, he has a legal status as that of the trustee. Now, who is competent to make transfer of the property? Section 7 of the Act provides that every person who is competent to contract, who is entitled to transferable property, and who is authorized to dispose of the property not of his own, can make the transfer of property either absolutely or partially. So first of all, this Section 7 provides that every person who is competent to contract. This competency to contract can be decided only with the help of the provision of Section 11 of Indian Contract Act 1872. This section says every person is competent to contract who is of age of majority as per the law to which he is subject, who is not of unsound mind, and who is not disqualified by law from contracting to which he is subject. Secondly, this section provides that the person must be entitled to transferable property. Entitlement here means that the person must have ownership or some title in the property. Only then he can make the transfer of the property to another person, because a person can transfer only that much title which he himself has in the property. This principle is based on a maxim which says nemo dat quod non habet. This maxim means that one cannot transfer better title than he himself has. So in order to make the transfer of property to another person, the person himself must have that much title which he wants to transfer to the another person. Then thirdly and lastly this section says that the person must have the authority to dispose of the property which is not his own property. So this property does not belong to that person, but still he is having the authority to dispose of the property. And these persons include trustee, administrator, executors, then manager of joint Hindu family property, as well as guardians. So only these persons are having the authority to dispose of the property. So the persons who are having power of attorney as well as Mukhtarnama in their favor, only these persons are having the authority to dispose of the property, and only these persons can make transfer of property as per the provision of Section 7. Then, what are the modes of transfer of property? These modes of transfer of property are discussed by Section 9 of the Transfer of Property Act 82. Section 9 says that there are two modes of the transfer of property. Person can make transfer of property either orally or in writing. So, if a person wants to make the transfer of property by oral way, it means that by mere delivery of the possession, the person can make the transfer of property to another person. So here section 9 says that where it is not expressly by the law, it is not given expressly by the law that the transfer of property can be made only through written documents, then only by mere delivery of the possession, property can be transferred. For example, sale of tangible, immovable property having value less than ₹100. Exchange of immovable properties of value having less than ₹100. Gift of movable property, month-to-month tenancy, then mortgage by deposit of title deeds irrespective of the amount. Then second mode of transfer is by registration. So through registration, property can be transferred. So wherever it is mandatory that property can be transferred only by written document, then transfer cannot make transfer of property by delivery of possession. So here, if it is required by the law that property can be transferred only by written way, then it cannot get affected in any other way. For example, sale of tangible immovable properties of value ₹100 or upwards, then reversions, then other intangible things of any value, transfer of actionable claims, gift of immovable properties, then exchange of immovable property of value ₹100 or upwards. Now here it is clear that if a person wants to make the transfer of property by registration, where it is mandatory to make the transfer of property through registration, then transfer cannot take place by mere delivery of the possession. So registration where is compulsory, we cannot opt for delivery of possession there. In Imperial Bank of India versus Bengal National Bank, 1913, volume 56, Calcutta 136, it was made clear by the court that partition, surrender, charge, they all are forms of transfers. But as per the provision of Transfer of Property Act, section 5, they are not transfer of property. Harihar Prasad versus Shri Guru Granth, 1930, Patna 610, it was made clear by the court that transfer to a idol, a gift to a idol is not a transfer of property within the meaning of the section 5 of this very act. So this transfer to idol can be made orally, but whenever transfer will be made of the property, it should be made fully. So section 9 of the act provides us about two modes of the transfer of the property. Thank you.